this disclaimer that the views expressed in this presentation are those of the presenters and do not necessarily justice. Let me tell you a little bit about the Elder Justice Initiative at the Department of Justice. And you can see it on the screen here. Its mission is to support and coordinate the Department of Justice's enforcement and programmatic efforts to combat elder abuse, neglect, financial exploitation, fraud, and scams that target older adults. And the initiative does that in a number of different ways. Promoting elder justice, providing help to older victims and their families and trusted others, enhancing state and local efforts through training and resources, and supporting research to improve policy and practice. I hope that you can hear. People are saying there's a little bit of trouble with the sound, but I will keep going. So this graphic gives you an overview of the many resources that the Elder Justice Initiative provides. You can find all of them on the website at elderjustice.gov. Many of the resources are aimed at a variety of professionals, and some of the resources are for the public as well. And in connection with today's webinar, I want to flag that we have some robust content on guardianship and less restrictive options to guardianship. So when you go to elderjustice.gov, if you look along the left side of the page where we have different topics, you'll find guardianship towards the bottom, and that will link you to the guardianship portion of the site. So now to today's webinar. We're thrilled to have Alison Hirschel and Nicole Shannon join me today. And I'll just tell you about them a bit briefly. Alison is the Director and Managing Attorney of the Michigan Elder Justice Initiative, where she oversees legal advocacy and ombudsman programs for older adults and people with disabilities. She's also a public interest / public service fellow and on the adjunct faculty at the University of Michigan Law School. She received her BA from the University of Michigan and her JD from Yale Law School. Nicole Shannon works with Alison as the systemic advocacy attorney at the Michigan Elder Justice Initiative. Nicole is focused on critical systemic issues such as guardianship, long-term care, and public benefits. She's a member of the Michigan Attorney General's Elder Abuse Task Force. She received her BA from James Madison College at Michigan State and her JD from University of Michigan. And finally, I'm Naomi Karp. I'm a consultant on aging law and policy for educational, nonprofit, and governmental clients, including the DOJ's Elder Justice Initiative. I'm a lawyer and policy expert who's worked on aging issues for over 35 years. From 2011 to 2019, I was Senior Policy Analyst at the Federal Consumer Financial Protection Bureau's Office for Older Americans. And I've previously worked at several other nonprofits. And I was a legal services lawyer for low-income and older clients. I got my JD at Northeastern Law School and my BA at University of Michigan. So you can see we have a trifecta of presenters who went to University of Michigan. Go Blue. Okay, moving along. So what are we covering on today's webinar? We are going to very briefly introduce you to guardianship and less restrictive alternatives. Then we're going to talk a little bit about what we call the dark side of guardianship, unnecessary deprivation of rights under guardianship, and the potential for mistreatment by guardians. Then we'll turn to potential avenues for change, and we'll focus on recommendations that came out of the recent 4th National Summit on Guardianship. Then Alison and Nicole will highlight many of the summit's recommendations using a realistic case scenario. And finally, our presenters will address implementing the summit recommendations in your state, strategies for action. So let me start out by giving a little bit of background on guardianship. On your screen, you see the National Guardianship Association's definition of guardianship. And in the interest of time, I'm not going to read that to you, but the important part is it's a legal process, and it's only invoked when a person can no longer make or communicate safe or sound decisions about personal things or property, or has become susceptible to fraud or undue influence. And here are a few other critical things to know about it. Guardians can be family members, friends, professionals, lawyers, or others. State courts appoint guardians, and guardianship law is primarily state law. The court has an ongoing role in monitoring the guardian's performance after appointment and in considering whether to end a guardianship. How many guardianships are there in the US? We don't know. The data are not robust. Many states don't keep the data. One estimate is that between 1 and 3 million people are under guardianship at any one time in the United States. And let me just talk for a moment about less restrictive alternatives. This is a very well-established principle that is generally enshrined in state laws, but not always followed in practice. Because guardianship strips individuals of their rights to make decisions for themselves, all less restrictive options should be considered and, whenever possible, utilized. And these considerations should start before a guardian is appointed, but can and should arise after a guardian is in place as well. So a practical approach is we should identify the specific problem that we're trying to solve, and then consider person-centered alternatives that would narrowly address the issue and avoid guardianship. Guardianship is a drastic deprivation of rights, and so it should be a last resort. So what are these less restrictive options? We don't have time to go into all of them, but you see a number of them on the screen. Some of these alternatives require planning in advance when the individual still has the capacity to understand these arrangements and put them in place. And these are things like financial powers of attorney, trusts, healthcare powers of attorney, joint bank accounts, and so forth. Some of these alternatives are available at any stage, regardless of the individual's cognitive abilities. And these are things like Social Security representative payees, conservatorships, which means it's just about the money, family consent laws, putting in home and community-based services, and then using more tailored one-time court orders rather than a full guardianship. We could do a whole webinar on these, but that'll be for another day. And now I'd like to turn it over to Alison.
What we're going to talk about today is that while guardianship can, of course, be a way to protect individuals who really do need protection, it can also be a way that individuals under guardianship can be abused, neglected, or exploited. Naomi's already referred to the fact that, of course, guardianship strips people of their rights. And this is something that Representative Claude Pepper noted many decades ago. He said that the typical ward has fewer rights than the typical convicted felon. Guardianship is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen, with the exception of the death penalty. And while Claude Pepper said that in 1987, it's still true today. And while I think many people think of guardianship as a benign protective device that just helps people who really need that kind of help and protection, we know that there is, as Naomi said, a darker side to guardianship. And that dark side occurs in a number of ways. For one thing, we have extraordinarily little data. Naomi mentioned we don't even know how many people are under guardianship. And we don't know a lot about what happens every time a guardian is appointed. So we don't know, for example, whether the person was present in court for the proceeding, whether they were represented by a lawyer, how long the judge took before they decided to appoint a guardian. And we also don't know much about what happens to people after the guardian is appointed, because in many states and jurisdictions, we have very limited oversight of guardians once they are appointed. Once someone is on that guardianship highway, it's hard to get off. So it can be very difficult to end a guardianship once you're in one. Sometimes we talk about it in Michigan as that highway without an exit ramp, or if it were a game of chutes and ladders, it's all chutes and no ladders once you're under guardianship. A Utah Judicial Commission described what happens in many guardianship hearings in a way that really rang true for me and for many people who do this work. They said that the appointment of a guardian or conservator removes from a person a large part of what it means to be an adult, the ability to make decisions for oneself. We terminate this fundamental and basic right with all the procedural rigor of processing a traffic ticket. In Michigan, our own Attorney General has talked about how she has been present in traffic court where cases have gotten more consideration than when a full guardian is appointed for someone in a very expeditious hearing where the person might not even be present or represented. So what goes wrong? Why is there this dark side? And so we know that often petitions are filed to address the needs, wishes, or convenience of other parties, not for the welfare of the alleged incapacitated person. It could be that there are longstanding family tensions and family members are trying to wrest control of an older adult or a family member away from someone else. It could be that it's expedient in order to get an institution's bill paid or to move the person on to the next level of care. But it doesn't always arise because it's what's in the best interest of the person at the heart of the guardianship process. We know that state probate courts have very few resources to properly investigate cases before a decision is made and to track those cases after a decision is made. We know that the due process protections, which often look so good in the statutes and the court rules, but they don't always show up in the actual court proceedings. So despite decades of effort to improve those protections, we know that, in fact, they're often missing in the actual proceedings. Sometimes, depending on your jurisdiction, there's sort of the cattle call hearings where many cases are heard all at once. And as I mentioned, the person might have no opportunity to present their side of the case. The medical evidence might be scant, and there might be a reliance on a diagnosis or a very cursory statement about that the person lacks capacity, and instead of a really thoughtful evaluation of what can that person do, what are the functional abilities as well as disabilities that the person might be dealing with. We know that plenary guardianships are appointed all the time, full guardianships when a limited guardianship might be more appropriate, and that's often because it's just easier to appoint a full guardian, and the court doesn't have enough information to carefully tailor and craft the guardianship so that it only addresses the areas where the person really has a definite deficit and needs help. Often the courts don't spend enough time going through all those less restrictive alternatives that Naomi discussed to see if any of those would be an appropriate alternative. And sometimes often courts tend to favor overprotection. They focus on safety rather than autonomy. We also know, as has already been mentioned, that there's just not enough oversight of guardians once a guardian is appointed. That goes back, of course, to a resource issue for many courts, but also just to a lack of focus on the importance of making sure that when we put someone in charge of another person's life, that person is doing everything they can to improve that person's life. I also mentioned that there are barriers to modifying or terminating guardians when circumstances change. We'll talk about that a little bit more later in the presentation, but that's part of the issue that once you get a guardianship, and often a full guardianship, it might be extraordinarily difficult to get off that track and change the guardianship as your needs and circumstances change. This is all true despite decades of efforts at reform in guardianship and despite many, many efforts across the country. Some of what I just said might ring true in your particular state. Perhaps in some states, some of the things I said aren't accurate because you have made progress in these reforms. But we're hearing from across the country that many of these issues remain, unfortunately, huge challenges for us in reforming our guardianship system. I'll turn it over to Nicole.
This is a really interesting time, I think, to be doing this work. I know that just before I signed on to do this presentation, I was reading on the front page of, I think, a lot of the national news organizations talking about changes to Britney Spears's conservatorship. And I guess personally, it makes my explaining my job a lot easier to folks. I'm now able to explain that I represent folks who are in similar legal situations to Britney Spears, but who typically aren't rich and famous and who are often, decades older than Britney Spears, who I believe is 39. So it's a really interesting time. And I think bringing this into the public consciousness means that more folks are willing to engage with the topic and potentially make some serious policy changes regarding this really complicated system that I think for so long has kind of existed in the shadows and part of maybe what might sometimes feel like kind of a niche practice, even though it does impact so many folks, like Alison was saying, and Naomi were saying, potentially millions of folks in the United States. There are so many more things that you might want to check out when you're done with our presentation. Guardianship in the media. I know that the first article that's listed here, How the Elderly Lose Their Rights, is a really heart-wrenching tale of one particular guardianship case. But I think for those of us who do this kind of work, there are many, the things that you see in that article are things that you see in your practice pretty frequently, all just kind of brought together. And I think in the spirit of, Go Blue and U of M, the article that Ronan Farrow wrote, his co-author is also University of Michigan graduate, about Britney Spears's conservatorship nightmare. I mean, these are all relatively recent articles. This is all brought to the brought into the public consciousness. And so I hope that when folks, leave this webinar and are thinking about, the ability to make, real systemic change, that you're leaving here, with kind of a fire in your belly. And, somebody in the comments is pointing out that the BuzzFeed article is very good. Now is the time to act. And I am so excited about the things that we might be able to do. But when we're talking about guardianship, it is important to ground it in reality, because some things are kind of sensationalized. There is the recent Netflix movie, I Care a Lot. And so, in addition to talking about, Ms. Spears, I'll also talk about the movie I Care a Lot, where the first, few minutes and few scenes are disturbingly true to life, with the systems where, folks seem to have this familiarity. There really don't seem to be many checks, where, the protagonist, where the individual who is subject to the guardianship is caught off guard to learn that somebody is now in charge of her affairs. All of that very true to life. Not so much, mobsters or people being tossed in trunks of cars. But there's also another film. It was produced by Cher, Edith, and Eddie. And it talks about a couple who are married, and Edith is placed under a guardianship. The documentary shares her experience in the guardianship system with the family feuds, the professional guardian, the challenges in being able to maintain the relationships that are important to her in life. And so as we have this discussion and, this is part of the discourse with guardianship, it is important to ground our conversation in reality, although unfortunately so many of these things that are kind of sensational aren't too far from the truth in some instances. So I will turn it back over to my co-presenters.
There we go. Sorry, I was having trouble getting unmuted. So Naomi mentioned the 4th National Guardianship Summit, and I want to tell you just a little bit about that. Approximately every 10 years, there's a national summit that pulls stakeholders from across the country to sort of create a blueprint for the future. What should guardianship reform look like over the next 12 years? And this year, that summit occurred in May. And Naomi and I were pleased to be included in that summit. And there were a number of recommendations that fell into sort of 6 buckets. I want to go over those briefly. I really encourage you to look at the National Summit recommendations. You can Google them, because there's a lot of detail there that we obviously can't cover in this presentation. But the first bucket, so to speak, was about rights-based guardianship. And in that bucket, members of the summit recommended things like a guardianship bill of rights and careful attention to the due process rights that we have been talking about for years, but that, as I said, don't always actually occur in guardianship hearings. Another area of attention for the summit participants was supported decision-making. Some of you might be familiar with this concept. It arose in the community of people with developmental disabilities. And the idea is that people with cognitive impairments might be able to make decisions for themselves if they had the support, the patient support and help of people they choose to help them make decisions. So the summit recommendations were that no one should get a guardian unless and until there has been an effort to see whether supported decision-making might be a less restrictive alternative and a way to empower people to make their own decisions. Another large area of concern was limiting guardianship, protective arrangements, and diverting pipelines. So that concerned, one of the bold recommendations in that bucket was that we shouldn't have plenary guardians anymore. That doesn't mean that in appropriate cases, we wouldn't actually provide all of the support that a person with severe cognitive impairments might need, but that we start with a more limited model and then build up to a plenary, to a more plenary type of guardianship, instead of starting with a plenary guardianship and never considering less restrictive alternatives. There was also a lot of attention in many of the groups that met for the summit to diverting pipelines, like hospitals that, for reasons that are understandable sometimes and sometimes just convenient, might be frequent petitioners for guardianship when a less restrictive alternative might be available. Another option, another area of interest was guardianship monitoring and addressing abuse. We know and have already talked about the importance of following up on the guardians once they're appointed to make sure they're really doing what they need to do to keep people safe and to empower those people to the greatest extent possible. The summit looked at addressing fiduciary responsibilities and tensions. One recommendation there was that guardians should be certified or licensed so that we really know who these people are. And there was a big focus on education so that they are well educated about their responsibilities, including least restrictive alternatives. And finally, there was a recommendation for a guardianship court improvement program that would be similar to an existing child welfare court improvement program. I'll turn it back to Naomi. Naomi.
Thanks, Alison. So I think you can probably gather from some of what Alison just described what the broad goals of the summit were, and we have them on the screen here, but just kind of briefly, a big emphasis on using less restrictive alternatives and also limiting the duration of guardianships when possible, rigorously adhering to due process protections. They're there in the laws and they're just not happening in the hearings and the things leading up to and following the hearings. Ensuring that guardians are diligent and educated, creating a system capable of rigorous oversight, and finally, embracing innovation focused on promoting the welfare of individuals. And you'll hear about some of those innovative ideas as we go through the case scenario that we're going to begin talking about now. So I'll turn it back over to Nicole.
In the pandemic. And so we are going to introduce you to 75-year-old Moira Rose, who in our scenario, and she's going to be the individual who's kind of at the center of this scenario. So she spent her entire adult life in the home she owns. It was once grand, but like in the show Schitt's Creek, it has now fallen into hard times and disrepair. And she was once wealthy, but now she relies on her modest Social Security check. Like many of our clients, she was hospitalized following a stroke, but now she's ready for discharge, and her doctors have said that she's expected to improve. She's got some limited mobility on one side, and she's got some speech impairments, which can sometimes make communication very difficult. She's also extremely fatigued. And so Ms. Rose is insistent. She wants to go home as soon as possible, and she can manage on her own. She does have a son, David, who lives in town, and she has a daughter, Alexis, who lives out of state. But she also has a large and supportive group of friends in her community choral group. The hospital social worker kind of disagrees with Ms. Rose and is concerned. She says, it's not safe for Ms. Rose to go home alone. And it doesn't seem like Ms. Rose really understands that it's not safe. And she's a little bit eccentric anyway. And so the hospital wants to file a petition for the appointment of a guardian. So what do we think is going to happen to Moira Rose? Well, right now, without implementing some of these recommendations from the Guardianship Summit, in many jurisdictions, that hospital's petition is probably going to be granted as an emergency petition. So that would not include much due process. It would probably be done ex parte. It would be done quickly. It would be done without Ms. Rose having much of a chance to really defend herself or explain her position before at least the temporary appointment of a guardian. And that could also mean that Ms. Rose could be headed to a long-term care facility. After all, she is being discharged from a hospital. The hospital is concerned that going home is going to be a dangerous situation for her. And so most likely that hospital would be looking at sending her to a long-term care setting, such as a nursing home, or for at least short-term rehabilitation. So assuming that a guardianship is granted, who's going to serve as her guardian? Well, if her kids aren't considered suitable or realistic, in a lot of places, the judges will appoint a professional guardian. And again, the incentives are not to, keep mom at home and ensure that she has what she needs, and maybe connect with her choir friends to bring her meals and to check up on her and to make sure she has what she needs. The professional guardian would have some different incentives, and moving to rehab or a long-term care facility would mean that it's kind of a one-stop shop, and the guardian would be able to do that without too much issue. And then even if she does improve, it's hard, I say a lot, that it's hard to put the toothpaste back in the tube once the guardianship is granted. It might be hard for Ms. Rose to terminate or modify the guardianship because in the court's eyes, she's already been considered to be legally incapacitated. And it can be sometimes hard to prove that there has been enough improvement in the eyes of the court that she no longer needs a guardian. So what facts should we be considering? Well, really the only evidence of Ms. Rose's incapacity is that she doesn't agree that it's unsafe for her to go home. And if she has capacity, what about the dignity of risk? If Ms. Rose, maybe if she were younger, maybe if she hadn't just gone through a stroke, would we really be considering, if this were an unsafe, if she lacked capacity, even if she did have some of the similar, physical disability she was dealing with, she's expected to get better, and she's got this whole community around her. We don't know if she has any alternatives to guardianship, like a power of attorney, but maybe she has enough capacity to be able to execute one, especially if she has a son who's nearby and if he's trustworthy. We also don't know what she could have at home to make it safe. Again, the hospital seems to think that just because it's an unsafe situation, she must not know what she's agreeing to. Whereas I think a lot of us are willing to risk a little bit of safety in the name of dignity and getting what it is that we'd like, especially, 75-year-old Moira Rose. Again, if she needs a guardian, who do we want appointed? And if it's a professional, what impact is that going to have on her and her family? And then the last question is, who is the hospital really protecting? And it looks like, in some places, hospitals aren't doing these guardianships, and it's a referral to APS. But again, is this really about the hospital protecting Ms. Rose, or is this about the hospital saying, if anything happens, it's not our fault? So I'm going to turn it over now to Alison.
Okay, so thank you. And so now what we want to look at is if we'd waved our magic wand and all of the summit recommendations had occurred in Ms. Rose's jurisdiction, what would happen before the petition is even filed? How would we approach this case? Well, Under the recommendations, every state would have a guardianship diversion project to facilitate alternatives to guardianship. So the way I picture that is in the probate court clerk's office, there could be someone whose job it is to talk to everyone who's intending to file, find out a little bit about the case, and encourage them to use the less restrictive alternatives that might be appropriate. Maybe there's even a checklist that helps people make sure they've considered every less restrictive alternative before they file that petition in court. And this is particularly important because we know that once you're on that highway, you're probably in many jurisdictions going to get a guardian, and then it's hard to get off. So to the extent that we can prevent Ms. Rose from ever entering the guardianship system and ever being considered by a court, we want to do that. That will really require training hospitals and other organizations that service pipelines to plenary guardianship about their legal and ethical obligations to exhaust less restrictive alternatives. We know that many hospital social workers are under enormous pressure just to move people out of the hospital, reduce the length of stay in the hospital, but they want to do the right thing. And if they're trained and educated about all the other alternatives to guardianship that they should be considering, we hope that they, combined with the court staff, will divert people who shouldn't be in the guardianship system. The kinds of alternatives that Naomi mentioned are the ones that we should be thinking about. Supported decision-making might work for Ms. Rose, an advanced directive, formal and informal services and supports, legal and non-legal alternatives. There are a host of things that could help Ms. Rose be safe in the community and have her dignity and autonomy when she gets there. Okay, over to Naomi. No? Yes? Oh, nope, sorry, still me. But what happens if that didn't work? What happens if, in fact, the hospital does file a petition? Oops, either the social worker wasn't educated or the court clerk was asleep at the wheel and the case got filed. Well, okay, there's still lots of ways that we want to protect Ms. Rose. First, there should be many protections that require the petitioner to plead affirmatively that supported decision-making is not a less restrictive alternative that would work in this case, and that all other less restrictive alternatives wouldn't work either. Ms. Rose would get meaningful notice. We want her to understand the import of this hearing. She'd get a lawyer to represent her if she wanted one and couldn't afford her. And she would be assessed in using a standard form that has the kind of meaningful, valid, and reliable information that will allow a court to decide whether a guardianship is appropriate in this situation. And finally, Ms. Rose, we'd be sure that she does understand the purpose of the hearing and that she has every opportunity to participate if she wants to. So now I'll
take a look at summit recommendations and how is the judge going to decide? To the recommendations to kind of, chart our course. The first is the standard. The court has to find by clear and convincing evidence that supported decision-making isn't feasible. And that clear and convincing standard is really helpful here, unlike that, standard preponderance of the evidence standard for most civil cases. Most guardianship factual findings are done by clear and convincing evidence, at least so far as those, threshold issues are concerned. And so that can be very important. Next is under that Uniform Act, which every state is encouraged to adopt. And I'll mention briefly, in Michigan, we are doing some serious overhaul to our statutes. And while we're not adopting this wholesale, it does serve as the basis for many of the changes that we are proposing. It is a fantastic resource. The judge couldn't impose a guardianship if there were some less restrictive alternatives that would meet Ms. Rose's needs. For example, maybe she doesn't really need anybody. Even if she were incapacitated, maybe she doesn't need a guardian to help keep her safe. She's got this community around her who can pitch in, and she's expected to get better, or at least improve in the future. I love this one, like we've talked about before, just completely getting rid of full guardianship. And so even if Ms. Rose did end up with a guardian, she should still be able to keep as many rights as possible, like free association, which is so important because she does have this, choral group. It sounds like she's very involved in the community, and being able to maintain those relationships is so crucial. The issue of whether or not guardians can interfere with those relationships or keep folks away from loved ones or friends or family. I know it differs from state to state, but I can tell you in Michigan, it's kind of an open question. It's something that there have been some recent legal reforms, but it can be really damaging when the guardian says, no, you can't see your loved one anymore. Religion, personal choices, marriage, voting, these are all crucial issues that need to be addressed, and depending on the contours of guardianship in your state, to ensure that Ms. Rose is not going to lose some of those vital rights. The court really needs to make sure that the order is exactly what, Ms. Rose needs and nothing more. And then lastly, if you do need a professional guardian, this is somebody who needs to have some type of credential, education, license, certification, something to be able to ensure that she has, somebody with, some training to be able to handle her needs. In Michigan, there was recently some testimony from a professional guardian who shared that a 16-year-old child came to court, filled out the paperwork, and made it onto the list to serve as like the next guardian for whoever needed somebody to be appointed. So at least here, not a lot of vetting. That's something that Ms. Rose doesn't need a 16-year-old calling the shots in her life. Next, what should we be thinking about after the court appoints a guardian? And at least in our office, often our clients come to us after the guardian has been appointed and the client doesn't really know what happened. They were caught up in this really traumatic experience. They weren't at their best. And so they need help undoing things. Well, what's changed from the time that guardian was appointed? And can we resolve any of those issues? Maybe there's some services that can help meet her needs. The doctors were predicting that her condition might have improved. Maybe her condition wasn't even that, difficult in the first place. Maybe it really didn't impact her capacity, but, you're going to have to bring something to the judge, most likely, to show that the judge wasn't, incorrect or didn't make the wrong decision. They're just ready to make the right decision now. Maybe there's even a neuropsych test you can take to show some improvements. Maybe there's something that's emerged in the meantime to show her needs can be met. Maybe her friends and family really have been pitching in to be able to, meet her needs, and there's nothing really for a guardian to handle. And that might also show that she's safe. And then finally, is there a preponderance of the evidence, or maybe, clear and convincing, and it depends on who the burden falls to and the standard in your state. But do we have something we can show a court that says, we need to make some changes here? Maybe that means termination, and maybe that means modification. So now I'm going to turn it back over to Alison.
Great. So now what we want to talk about is, despite the summit recommendation, somehow Ms. Rose still ended up with a guardian. So what kinds of protection should we be assuring her that she will receive once she's under guardianship? Well, the first thing is there has to be a really vigorous and helpful monitoring system. And that will help the court know if there's, for example, if we use uniform forms, it will help the court know exactly what's going on with Ms. Rose. Another important recommendation was that there be written care and financial management plans. And if you have a plan that the guardian has to put together, then there are benchmarks that guardian should be meeting. And if the guardian can't meet those benchmarks, if he's not able to do what he promises or she promises to do for Ms. Rose, then the court will be able to ask for an explanation of why aren't those good things happening for her. In order for this to work, of course, the courts have to have the ability to review the guardian's reports and accountings frequently and carefully, and they have to have the ability to have in-person visits periodically with the person under guardianship, because otherwise we really won't know what's happening to that person. There's a lot of mistrust in our state and probably in other states of the whole guardianship system. So the summit participants were sensitive to that and suggested that there be a complaint process that's accessible and user-friendly and transparent and effective. That there was a recommendation that it be a statewide entity that's independent, not just from the court, but independent of the court that appointed that guardian, to make sure that the guardian's conduct is appropriate. So that could be a guardianship ombudsman, it could be a state office of the guardian that investigates complaints, but it's some independent body that can follow up on complaints and make sure that the guardianship is working to the person's benefit and necessary, and not responsible for abuse, neglect, or exploitation of that person. The summit participants wanted at least annual judicial in-person review. Again, unless it's in person and you really see that person under guardianship in front of you, it's hard to tell what's really happening. If Ms. Rose needs a lawyer, she should have access to a lawyer even after the guardian is appointed, and that might be essential if she's ever going to modify or terminate that guardianship. And we know that some of the recommendations are expensive, so the summit participants tried to make recommendations that were both practical and cost-effective. There was a suggestion to use trained volunteers to visit and advocate for the adults' rights and preferences, and that way the court can still get the information, but it will be less expensive than having court staff do it. And we know of programs where trained volunteers have been very effective in this role. But we also want to talk about, how does Ms. Rose ever get her rights back? And the summit thought a lot about that. So the summit participants recommended that she have access to full or partial restoration of rights as soon as possible. And that, as I said, that has to be able to be triggered in formal or informal means. She might not have the ability to make a formal, but file a formal petition. But if she can notify the court that she thinks that her rights should be restored, then she should be able to pursue that with a qualified lawyer if she can't pay for one herself. The court should engage in meaningful review of her situation and give her notice every single year, and that in a year is a long time in a person's life, but at least every year, that she has the right to have her rights restored or partially restored. A big focus of the summit participants was education, as I've said before. So everyone in the process should be trained just as much on the restoration process as they are in the process of appointing guardians. I think that's where we often see things fall apart. People know how to get a guardian, but then they never think again and aren't trained in how you undo that process when it's appropriate, as it so often is. The guardian shouldn't be able to interfere with Ms. Rose's rights being restored, and should in fact facilitate that restoration when the guardian recognizes that Ms. Rose is able to regain control of her life. And then, very important, in order to demonstrate that that her rights should be restored, Ms. Rose would only have to show a preponderance of evidence that she should indeed be able to make her own decisions again. Okay, so I will turn it over.
We feel like every jurisdiction might be able to consider. The first Act. And like I mentioned before, in Michigan, it does serve as the blueprint for so many of the changes that we want to make. I'm sure that every state has things where they feel like there are things that work particularly well, things that don't work so well, and then maybe some things that are just so integrated into the system that it's really hard to just, toss them out. And so you can adopt, what's in the Uniform Act to your needs. But it's a fantastic resource. Next, take a look at some sustainable pilot projects to target diverse populations. Something that we're talking about is guardianship diversion projects, where instead of having that first guardianship hearing, you would be connecting folks with resources in the community that might make the guardianship unnecessary, such as home and community-based services, and information on other things like powers of attorney. Next is, let's get some data. I see so many comments in the chat that are about data, and we don't know what we don't know in so many of these cases. And so by really working hard to gather this information, we might have a better sense of the scope of the issue and how we might be able to best address it. Next, look at some multidisciplinary, multi-state, and local collaborations. This could be anything from having a local vulnerable adult collaborative, perhaps with your local legal services office, your county district attorney or prosecutor, law enforcement, adult protective services, providers, just folks in your local community who handle things like this, all the way through to a truly statewide type of collaborative. Including members of the state judiciary, administrative office, and high-ranking officials. Really, you can make the change at any level. Next, training. What more do you say about that? We could all use some. And then next, establishing a national court improvement program, and you can learn a little bit more about that by taking a look at some of these recommendations, 6.1 through 6.3. So I'm going to turn it back to Alison.
So I do have to say that we're not Pollyannas. We know that there are many challenges, that we don't have a magic wand to make all the summit recommendations come true. We've listed some of the challenges here. We don't think that any of these are necessarily insurmountable as long, and we'll talk in our last slide on a more hopeful note. But I do want to highlight a few of these. One of the issues that we know we're up again is that human nature is reluctant to change, right? We know what we know and we know how we do what we do, and it's hard to change. And there are a lot of people involved in the guardianship system who are very invested in believing that they're doing something good, that they're trying to protect people. So having people adopt a whole new vision, including, for example, the idea that we wouldn't have plenary guardianships, that's going to take some work, but it's really important. And that's why the training and education is so important, so we can move people toward really wanting to embrace those changes. We know that there's an institutionalized bias, so that a lot of people think that nursing homes are the safest place to put someone who might have some cognitive impairments. But many of us who work in that world know that nursing homes aren't necessarily safe, and that people who have more control over their lives tend to have better health outcomes as well. We know these cases are messy because capacity itself is an incredibly messy and difficult issue. It changes, capacity can change over the course of a day or a few weeks. And capacity to do one thing might be different from capacity to do something else. So, and the last one that I wanted to highlight is just that sometimes there's a lot of attention to elder abuse and elder justice these days, but sometimes people forget that guardianship is a key part of that discussion. So when you're talking about your local coalitions to combat elder abuse, let's make sure that you're talking about guardianship and the role it plays in that field as well. We'll end on a more hopeful slide, so I'll turn it back to
examples and potential partnership, templates that you might be able to use, such as wings. And if you want more information on wings, I urge you to take a look at that. I know many of our friends who do this work are heavily involved in it, and it's a great guardianship reform type effort that folks can undertake in their own states. Next is, think about legislative changes versus practice and culture changes, because sometimes it seems like the answer is to, just change the law or make some legislative change. But I think we know right now that, at least in Michigan, even now the laws are not followed, at least with in the spirit of the law. And so much of it is really just a culture change that needs to happen to empower individuals, to make clear that, the dignity of choice is important. And also, probate courts are under a tremendous amount of pressure to not be in the headlines because they chose to permit somebody to handle their own affairs by denying a guardianship petition, and then, oh, look at this terrible thing that befell them. So, think about legislative, but also think about, how far is that statute really going to get you, and how do you need to make some culture changes? consider a statewide summit to put some of this into practice and include those important folks along the way, like state court administrative offices, or maybe some key judges in your state who tend to hold some sway and who are maybe seen as thought leaders, and involve the state or local elder justice coalitions that may exist in your states. And if they don't, again, going back a couple of slides, maybe try to put one together, because they can be invaluable, even if you do it at a very, very local level. So with that, I think that it is time for questions. And I think that Naomi, is kind of our moderator for this.
Oh, and we have some great questions. So I'm going to throw some of those out to Nicole and Alison. So here's a question based on our wonderful case scenario. And I think, Nicole, why don't you stand by for this one? So the question is, what if Miss Rose's daughter lives with Miss Rose and always has, and Miss Rose relies on daughter for support? Mom wants to go home with daughter's support, but the daughter has no income, and social workers and the judge seem to think the daughter is exploiting mom.
There's an assumption that if the adult child is still living at home, there's something going on there, and they're trying to, take advantage of the situation. Whereas perhaps they're really there because they're caring for mom, and caring for mom takes up a lot of time, and it might make it difficult for her to earn much money or hold down a full-time job otherwise. And so I'd really want to investigate what's going on there. It may well be that there is some exploitation going on there, and I work with a number of attorneys who handle those very types of cases. But I think it's important to really dive in. And then the other thing is, maybe Ms. Rose is okay with that. I think it's difficult, but maybe Ms. Rose is okay that, that's, it keeps her daughter close by. She wants to go home and she's fine with that. And I think it just keeps on returning to, is this a capacity issue or is this a choice issue? Because maybe, she knows that Alexis is up to no good, but it keeps Alexis nearby. She's, Ms. Rose is comfortable with that. And that's just kind of the life she's chosen for herself. And she's well aware of the consequences. But that's her dignity of choice. So I think those are a few things that I consider along the way. But if Ms. Rose is concerned about, maybe being taken advantage of by Alexis, then I'd send her to my friendly local legal services attorney and see if they can assist in maybe getting Alexis out of the home so that Ms. Rose can return in dignity and safety.
Completely agree with what you said. And again, that's why the summit recommendations talk about being person-centered. It really, if Ms. Rose has the ability to understand what's happening with Alexis, it's her choice whether she wants to be in that situation. And we can certainly offer her alternatives and ways to address that situation, but we don't want to make the determination that it's in her best interest not to be home with Alexis if that's her choice.
Courts are moving towards Zoom hearings. What reasons could be presented to support in-person hearings? And I guess I'll take a first crack at that. We definitely have heard from some courts and anecdotally and from some of the wings groups around the country that during COVID, courts were starting to have hearings on Zoom or through some other remote audiovisual platform. And in many cases, these were in emergency guardianship petitions, not all of the hearings. And I think they're trending back more towards more courts having in-person hearings. And I guess what I wanted to point out is the questioner is suggesting that in-person hearings would be better. But we learned from some of the judges and other people in the states, especially in the midst of COVID over the past year, that actually there were some advantages to these Zoom hearings. they actually increased the opportunity for the person who was the subject of the guardianship petition to participate, because the person might not have been mobile, might have been in a nursing home or some other place where they actually could have been zoomed in. And so it actually could increase their due process rights and their abilities to participate and perhaps to object to the guardianship. So there is some upside. There also is an upside in having more family members or people who might be scattered around the country participate in those hearings. So there actually is some argument that it's a better and a more fulsome process. On the other hand, there is some concern that when you have something remote, there's more opportunity for fraud. Someone could be coaching someone out of the view of the camera, and it's judges say it can be harder to kind of assess the credibility of the witness. So I suppose those are arguments for supporting in-person hearings. I guess I'd like to also throw it out to Nicole and Alison, whether you have any thoughts on in-person versus Zoom hearings.
I think you covered it well. I don't know if Nicole has anything to add, but I think you really hit the high point.
For your client, and that might mean we need to have an in-person hearing technological issues make it difficult to communicate and really understand everything that, really, take in everything that's going on. And I think that you can make that request and say, you want to assess capacity. You don't want to assess whether my client has, hearing loss or whether it's difficult for them to communicate using Zoom. Let's bring this in. And at the same time, you can say, I've got a client for whom transportation is very difficult. They reside in a nursing home. It would be very challenging and potentially dangerous for them to travel all the way to the probate court. Let's do this through technology. And so I think that we as advocates have an opportunity now that we've seen what is very possible to request these accommodations without it seeming like something that's really out of bounds or unusual. We just did it for the last 18 months and we can ask for it for whatever fits our clients' needs.
Isn't it true that in the vast majority of cases, guardianship is applied properly for the affected person? And I will throw that one back to Nicole and Alison.
We wouldn't know because we don't have enough information when the judge is making that decision. Restrictive alternatives would be appropriate. That's the first thing I'd say. The second thing is I think it does depend on the jurisdiction and even on the judge about how careful an evaluation they do and whether the values of how they consider the values of safety and autonomy. Nicole, did you want to add to that? Yeah, once we have the data and the thorough reports and analysis and all the other things we were talking about, I think we'll have a better
we'll be able to have future webinars that will go into some of these aspects and other aspects of guardianship. But on behalf of the Elder Justice Initiative, I'd like to thank Nicole and Alison so much for participating and doing a great job here today. And also thanks to the audience for being so attentive. Sorry, we had some technical problems. Thanks for your comments in the chat box and your questions. And there were some other questions, so we have them, but please email us. I'll just go back again to that slide. elder.justice@usdoj.gov if you have questions that you would like to have answered after the presentation. And with that, I think that we will wrap it up.